This is Professor Porter. Today we're talking about some law school essay writing, in particular crafting rule statements, and I'm going to talk about the confrontation clause as an example, something you learned in evidence, kind of a newish topic in the last 10, 15 years that gets tested on the bar under evidence, mostly as an essay topic, but it's a developing area, and maybe you learned something because you haven't covered it yet in your law school course. So one of the issues that comes up, and I think one of the disservices that happens with thinking about essay writing, is we talk about rule statements. And I think oftentimes that's confused by folks learning for the first time in law school, writing an essay. They think it's a sentence, a rule statement, like a statement. And here's one right here. Here's essentially what the Sixth Amendment says, modified a little bit with what the Supreme Court said in 2005 in Crawford v. Washington. But it's essentially a bland statement of law, black letter law. That's what we mean by a rule statement that doesn't cater to the problem that's before us. So we're talking about the law, and we're essentially trying to furnish in our rule statement all the law that we will need to argue for one side and then the other below in what's called the analysis section before we arrive at a conclusion. That's your typical IRAC fact pattern. And this is one of the things that happens. Here's the Constitution, Sixth Amendment, a statement of black letter law. But this statement alone, as it had to be clarified by the Supreme Court later on, doesn't have enough to arm you to analyze your next case, your next problem that you get on a law school exam. So this would be inadequate in my mind because it's just a sentence, but not a full rule statement that can help you analyze. Similarly, here's a good, accurate rule statement that comes from the Supreme Court in Crawford. I think this is something you would see on the law school exams under a confrontation clause of what the Supreme Court said. The Supreme Court in Crawford established that testimonial evidence would include, and it actually has a definition. The case was helpful in the sense that it had a definition, ones that declarants would reasonably expect to be used prosecutorially. So if I'm sitting down with law enforcement in a custodial examination, or if I work for a drug lab affiliated with the government and I fill out an affidavit as to the weight and purity of the drugs, like those are statements that I would expect to be used prosecutorially. If I'm the person sitting down as the declarant with the police, providing a statement in a custodial setting at the police station in an interrogation room, or if I'm, an expert witness, a chemist that works for a drug lab, and I produce an affidavit, a drug report that talks about the weight and purity, I can expect that those statements are going to be used prosecutorially. Those would be testimonial, and therefore you need a warm body in court, and you need someone that's there to be cross-examined. Well, this is an accurate statement, but it's sort of without context. You might be able to get a little further in your analysis because at least it has one definition, one test. But I think it's a mistake not to include that this right comes from the Sixth Amendment, comes from the Constitution. It's a constitutional challenge, not an evidentiary objection. And really, it's inadequate. It's a strong path to partial credit on an essay just in the rule statement alone. Same thing with this. If you just put, hey, testimonial evidence is bad under the Confrontation Clause, it would be excluded unless you had some prior opportunity to cross-examine. Yeah, that's an accurate statement too. That's sort of the remedy, and that's part of the rule statement, but I don't think it includes it all. And I read essays that look like this. They might have the broad statement from the Constitution, from the Sixth Amendment, as to what's the right that we're talking about with Confrontation Clause. What is the right to confront witnesses against her for the criminal defendant, and essentially what could get by it, what could help it with a prior opportunity to cross-examine. But it misses the point of the whole thing that seminal case did in Crawford v. Washington, was to define testimonial evidence and define what is not testimonial evidence. And that's the type of information that belongs in a rule statement that can help you analyze your next problem that'll come up, in an essay question. Probably looks something more like this. So, again, we do a little bit of a disservice when we talk about rule statements as one sentence. I think it starts with the broadest application. It's more like a rule funnel. The broadest application of the Sixth Amendment and the Constitution, that statement, what the Supreme Court said and how it defined testimonial evidence is essentially the test. Again, custodial and examinations and affidavits are those things that we can reasonably expect to be used prosecutorially. That's going to be in the good pile. That's going to be things that are testimonial, things that require cross-examination. But then the Crawford Court went on to say, overheard testimony, casual offhand remarks, those things are not testimonial. Depending on what the problem is, if it's just a straight example, I might put that in as well, and then I would put the last sentences. This is getting closer to, this is a full-blown rule statement funnel. This is an accurate rule statement that can help you tackle most problems that you'll be confronted with under the confrontation clause. And here's a sample. I don't want to go through it. You can screenshot this if you need to read it, but here's a sample analysis. I like to demarcate, and a lot of professors like to see demarcation of analysis here. So now I'm talking about this case. I'm talking about this problem you gave me. I'm talking about George's statement to the park ranger. So here, essentially in 2 paragraphs, we're going to see an argument for one side that it's testimonial and an argument for the other side that it's non-testimonial. And you'll see if you read through this paragraph, they're using the law above. How the Supreme Court in Crawford defined testimonial and defined non-testimonial. So the first paragraph is sort of the defendants. This is the criminal defendant saying, hey, this is the type of stuff that should be excluded. I have the right to confront witnesses against me as a criminal defendant. If this statement is testimonial, I enjoy that right under the 6th Amendment. So that's what we're talking about. And they basically say it's akin to an examination and affidavit. That's a good argument. And the most important words you see here highlighted in yellow, because you can't make an argument. You can't have an analysis section without taking some of that law and applying it to this fact. So why is George's statement in this case akin to a custodial examination and affidavit, so therefore testimonial? Because, and then you see it. And at the end in blue, you see the arguments. The defense is arguing George's statement was testimonial. That's the most important thing that they can do under the Confrontation Clause, to say this is testimonial, so we should see cross-examination or we shouldn't hear this out-of-court statement. Conversely, the paragraph that starts, the second paragraph here, the prosecution will argue. This is the flip side. This is you demonstrating for your reader, for the professor or the bar grader, I can argue both sides of this. The prosecution is going to argue this is non-testimonial because, and it's more like the casual offhand remarks. That was the Supreme Court's definition of non-testimonial. And you can see they argue. And then they put their prayer for relief at the bottom as well. Accordingly, the statement is non-testimonial and does not violate it. So we can let it in, assuming it's non-hearsay. And if you notice, if you do this the right way, if your analysis is the right way, after the word here that demarcates, hey, I'm in the analysis section, professor, I'm done with that rule statement section, the conclusion is less important. You've probably heard law professors say this before. The conclusion is the least important thing. It's the thing I devote the least points to in my rubric when grading. Because if you do a good job like this of setting out a full-on rule statement funnel that goes from the broadest application of the Constitution into the cases that matter, and then you argue effectively both sides using the rules from that case, from that authority, whatever it may be, then however you come out in the conclusion is less important, and I award less points for it, because this right here alone, before you see a conclusion, demonstrate that this person knows what they're doing and knows what they're talking about. Here you see it, kind of on a full page, full rule statement in yellow, full analysis section, the arguments for both sides in white with some of those words highlighted. This also happens, there's some developing law that followed in a couple cases, essentially when people are calling 911 or reporting to law enforcement on the scene of a sort of ongoing criminal event. So they might be reporting somewhat historically, but they might also be trying to remedy an ongoing emergency. So there was some Supreme Court cases following Crawford in 2005 that had to deal with this. So in this case, when you're calling 911 and reporting something, you can expect that could be used prosecutorially as the declarant, but also talking to law enforcement at the scene, you're doing so because you're trying to be helpful to a criminal investigation. So it's most likely, it's not one of these, is it testimonial or is it casual and offhand? So this part of the rule statement that's in white, that's crossed out, may be less helpful and not needed in a rule statement to analyze this. Instead, we might have to substitute something in there. And the Supreme Court in Davis, as you'll see, and other cases like it, they came up with what's called a dual purpose test. And the dual purpose test says, if this statement that the out-of-court declarant is making kind of has two purposes, maybe it does something historical, it provides some historical account, like you would if you were sitting down in an interrogation and saying what happened to the police or law enforcement. But it also could remedy an ongoing emergency. Something's going on right now. Maybe the criminal defendant's not apprehended yet and is around. Maybe there's an ongoing danger. Maybe there's a medical need. Well, then the Supreme Court tells us in Davis that the primary purpose of that statement controls whether it's testimonial or not. If the primary purpose is historical, then it's testimonial. If it's to remedy the ongoing emergency, then it's non-testimonial. So now that part, the part in white here that comes from the Davis case, it still has to be in the context of my funnel. It's still derived from the Supreme Court in Crawford, and before that, the Sixth Amendment to the Constitution. It still requires the same remedy in the last yellow paragraph, that it's going to be excluded unless there was some opportunity to prior opportunity to cross-examine. But now this part in white, because it's sort of a primary purpose, dual purpose type of fact pattern that I received when I'm looking at my next problem, well, then I have to take that on, and I need this law to help me sort through it. And now my analysis will look different. You know, it still has demarcated with here, so you know I'm analyzing and I'm applying that law above to my facts. You see in yellow the words because, so I'm basically arguing, hey, one's backward-looking historical account, the other one I'd say because it was more like an emergency to resolve something that's ongoing. I'd still have my, essentially my argument straight. If I'm for the government, I'm basically still saying, hey, this is more historical. That's the primary purpose of that 911 call. So Elaine's testimony was testimonial, her statement. So that's helpful, right? I keep it organized. The defendant's still arguing this, but what does that mean under the primary purpose test with that extra law that I arm myself with in my rule statement in that third bullet? And same thing below, I'm making sure to keep my side straight. Number one thing that happens, especially in confrontation clause, but it happens all over the place in legal essays, get it straight. Who should be arguing what result? Who wants what side? Here, the defendant wants to call it testimonial, because if it's deemed testimonial, they're entitled to cross-examination. And if this person is no longer around, or you're not going to be able to confront it, it means the statement's out. The bad statement that they're trying to keep out is out. The government is always arguing non-testimonial. Don't worry about the Constitution. Don't worry about the Confrontation Clause as a challenge to exclude this. Just the rules of evidence, just hearsay, as a different hurdle that needs to be overcome. And again, if you do a good job with this, the conclusion's less important. Hope this helps.